Very well. As you each know, each side will have 15 minutes to present oral argument. Appellant will proceed first and may reserve up to 5 minutes for rebuttal, and I'm keeping time, so please let me know if you want to reserve time.
Please the court. Again, my name is Kathleen Amerkanian, and I am representing father on this appeal. In this case, and I would like to reserve 5 minutes for rebuttal. Thank you. In this case, this is a termination of parental rights case. The agency became involved with this child when a younger sibling of the child actually passed away as an infant. The agency investigated. They had had a prior history with the family, and due to concerns of drug use by mother, they became involved, and DB was adjudicated neglected and dependent.
Now, was that adjudication agreed upon by mother?
I do not recall whether it was agreed upon. I am sure that my opposing counsel will know that. The appeal really is just challenging the termination of parental rights of both father and mother. And the main issues relating to father revolve around the admission of hearsay evidence pertaining to drug screens. Drug screens were never, results of drug screens were never introduced into evidence. They were testified to by the caseworker, and father never conceded that he had been using drugs. In fact, he pretty vocally opposed the validity of the results. And in conjunction with that, father very vocally expressed dissatisfaction with his trial counsel. And so we've also included an ineffective assistance of counsel in this brief, because there are many instances throughout where trial counsel failed to object to hearsay evidence. And it's very clear from the record that father felt misrepresented and felt his trial counsel was not defending him with regard to that. The other issue involved in this case is really whether there was enough evidence as far as the best interest factors for the court to terminate parental rights of mother and father. One of the cornerstones of the best interest tests that this court has pointed to is the interrelationship between parents and child. There was ample evidence that mother and father in this case both had a good bond with the child. They participated in visitations. There were concerns by the agency that father had issues with his temper. There was never anything presented at the permanent custody hearing as far as any kind of criminal cases, any kind of mental health testimony. All of the instances that were presented were really instances of father becoming angry with the agency, which is, as this court knows, is really, can always sometimes be seen as a parent simply becoming frustrated with the people who are taking their children from them. And so the instances of anger in this artificial relationship was really the only instances of anger management that the agency had pointed to.
But what you refer to as an artificial relationship, and I do understand your use of the term, is the channel through which father has to travel in order to establish that he can properly parent the child. And so his anger gets in the way of allowing the staff of the agency to do their jobs, to be able to assess, his capability, then it's sort of a self-inflicted wound, isn't it?
To some extent, however, I think it's worth noting that I do not believe there were any instances where he is losing his temper with the child. I mean, the interaction between him and the child was not involved in this. And so, you get instances where after visitation was over, he would have some negative interactions with the agency. But I think it's also worth noting that there was no other instances of violence. I mean, when you have somebody who's not only picking fights with the agency, but also is out there picking fights with other people, I think that would be a stronger case. However, in this case, you really only had him not getting along with the agency. The other problem in this case was the agency's continued reference to the fact that father and mother had multiple physicians and multiple prescription medications. There was no testimony from any physicians or any medical professional that their prescription medications were not validly prescribed. In fact, they were validly prescribed. They had prescriptions from various doctors. There was no evidence that these doctors weren't aware of the fact that other doctors were prescribing medications for them. You had two people who, I know that father received disability. I believe mother may have also received disability. So they had various ailments. But the agency and the trial court, this was part of the trial court's analysis as well in terminating parental rights, took really what was speculation and extrapolated that, not failing to acknowledge that there was really no evidence that the prescription medications were inappropriate in any way. If there are no questions, I will save the rest for my rebuttal time. Thank you.
Good morning. May it please the court, my name is Emily Kirsch, and I represent Lorain County Children's Services. In this case, both mother and father filed briefs. Their assignments of error were somewhat similar. Father had a couple additional ones, so I will address them together. To answer your first question, Your Honor, the adjudication entry, I believe, was agreed upon by mother and father. Additionally, there had been a first extension, and that, I believe, was also agreed upon by mother and father. In order for Children's Services to obtain permanent custody, it must prove both prongs of the two-pronged test in 2151-414B. Under the first prong, Children's Services must prove that one of the conditions set forth in 2151-414B1, A through D are present. And under the second prong, it must prove that it's in the best interest of the child to be placed in the permanent custody of Children's Services. In mother's brief, she challenges both of these trial court findings. Father, however, does concede that Children's Services did prove the first prong of that test. The first prong that children proved was that the child had been in the temporary custody of Children's Services for over 12 months of a consecutive 22-month time period. That's the 12-22 provision. Mother challenges the trial court's findings under other conditions in 2151-414B1A specifically. However, this court has held that once there is a 12 of 22 finding, any errors as to alternate findings is not a reversible error. So Children's Services did prove this first prong. Under the second prong, the best interest factors, this prong was challenged by both mother as well as father in his fifth assignment of error. In order for the trial court to find that it's in the best interest of the child to be placed in the permanent custody of the agency, it must consider all relevant evidence, but specifically the factors in 2151-414-D1. Under the first factor, the court must look at the interaction and interrelationships of the child with the parent, foster caregiver, or any other significant person in the child's life. This factor weighed in favor of granting permanent custody of the agency. As to father, the testimony established that father actually had little interactions with the child during visitation. The caseworker testified that father would sit in the chair and read the newspaper, and that mother did the majority of the parenting. Furthermore, although appellant has attempted to argue that father's temper was limited just to interactions with the agency, that's not what the record showed. The record showed that father would yell and scream and call mother's name in the presence of the child during visitation. Additionally, father's temper was also seen during the court proceedings. When he was testifying, he continually tried to plead the fifth for certain things. He actually had to consult with his counsel and be instructed that you need to answer the question that's asked. 2 times during the 3-day trial, sheriff deputies had to be called because father's temper was getting a little out of control. Additionally, the testimony established that between, I believe, the first 2 days of the permanent custody hearing and the 3rd day, father had seen the guardian ad litem out in public and approached her and threw a sandwich on the ground at her. Additionally, father's interactions he had concern about interactions with the child, as there were a couple times when mother was not able to attend the visitation and father would request that the visitation time be lessened because mother did the majority of the parenting. As to mother, the testimony established that her interactions were not always positive due to the substance abuse and mental health issues that she had. The caseworker explained that she did not think that mother would intentionally do anything to harm the child. However, there were some deficits with respect to her substance abuse that could cause some neglect towards the child. The testimony established that the child had a very strong bond with the foster parents and was well adjusted to the foster home. This factor, therefore, weighed in favor of granting permanent custody to Children's Services. The next factor the court looks at is the wishes of the child as expressed through the guardian ad litem. This factor weighed in favor of granting permanent custody because the guardian ad litem recommended permanent custody. Under the next factor, the court looks at the custodial history of the child, including whether the child has been in the custody of the agency for 12 of the previous 22 months. And as I previously explained, the child had been in the custody of Children's Services for over 12 months. The next factor looks at the child's need for a legally secure permanent placement and whether either parent can provide this placement. This factor looked at whether or not the parents had addressed their issues that were on the case plan. Both mother and father failed to address their substance abuse issues, their mental health issues, and failed to demonstrate a consistent ability to meet their own basic needs. Appellant mentioned the concern about the prescriptions and whether or not the parents were taking their prescriptions as prescribed. The testimony was very clear that father revoked his releases of information. Children's Services had no information concerning whether or not he was taking medications as prescribed. Furthermore, he testified as to 3 different doctors that he was seeing throughout the life of this case and the various medications that they were prescribing. The caseworker had testified that based on her conversations with father, he indicated that he was taking oxycodone for such a long period of time that if he stopped taking it, he would have withdrawals. He further had told the caseworker that he was looking to go on to Suboxone to help with the withdrawals. So because of that, yes?
He was getting those prescriptions, however, legally.
Children's Services had no evidence.
They don't know.
We do not know, Your Honor.
You don't know that it was illegal.
We don't know, correct, because he would not sign releases of information. The case plan does provide to sign releases.
That's mandatory in the case plan.
I believe that was in the case
Okay.
plan to sign releases. So because of that, it was clear that the parents could not provide a legally secure permanent placement. In both mother's brief and in father's first assignment of error, they claim that the trial court erred by not granting custody to a maternal aunt that mother had filed for custody to go to. However, there were several concerns with this maternal aunt, which is why the trial court denied granting legal custody to her. The first concern was that mother and father did not even provide her name until after the child had been in custody for over a year and a half. The testimony established that the caseworker consistently asked the parents for names of relatives or possible caregivers. The caseworker testified about her efforts when she received those names, such as calling those relatives, asking if they could care for the child, and then asking those relatives if they knew of any other relatives. Additionally, once the caseworker learned of this relative in August 2015, she called Ms. Brooks repeatedly and put in a request for a home study. The Ohio Administrative Code sets forth that for someone to be considered as a placement option, they need to get fingerprinting done because if they have certain offenses, they are excluded from being approved as caregivers. Children's Services requested that the maternal aunt get the fingerprinting done. However, she delayed in getting it because she was asking mother to pay for it. When she was questioned as why she did not use her own funds to pay for it, she said it's because it's for mother's kid, not her kid. That raised concern about her commitment towards caring for the child. Additionally, the aunt had not visited the child in over a year and a half. The child was 3.5 years old, and she had not seen the child since he was about approximately 15 months old. Children's Services requested that she come up to Lorain County and visit with the child, and even offered to provide her with a gas card to visit with the child. However, she still never came to the agency to meet with the child to set up a relationship with the child. Additionally, the testimony established that there were concerns about whether or not she would be able to meet the basic needs of the child. When she testified about the finances that she had coming in, such as Social Security and child support, it was very clear that her expenses exceeded the money that she had coming in. Furthermore, she did not have transportation as her car had been broken down, and she indicated that she was not able to get it fixed. So because of this, the trial court did not err in failing to grant legal custody of the maternal aunt. This court has held that the issues of denying legal custody to a relative and granting permanent custody to the agency are really two sides of the same coin. So that if the court finds it's in the best interest to grant permanent custody to the agency, it would not be in the best interest to grant legal custody to a relative. And because of the factors that I just set forth, it was proven that it was in the best interest to grant permanent custody to the agency. I'm going to address mother's other assignments of error.
But before you do that,
yes.
Could you speak to whether father has standing to address issues relating to mother?
Yes, Your Honor. I believe that father does not have standing to address issues related to mother. In father's brief, he cites certain cases that indicate that he would have standing. However, my reading of those cases appears to be limited to just a situation where a parent is appealing a trial court's denial of a motion to a relative, not something that would affect the parent's right. In this case, mother was a party to the case. She participated actively in the trial. She had her own trial court counsel, and she has her own appellate court counsel. Therefore, I do not believe that it is proper for father to be raising issues as to mother.
But there wasn't a definitive court case where we have or any of our sister courts have held that the party would lack standing. At least I don't recall you citing.
Your Honor, I believe that I may have cited other district court cases. I know that the 9th District has not decided that specific issue.
All right.
Any other questions?
No, go ahead.
Okay.
You have 4.5 minutes remaining.
Okay, thank you. As to father's second assignment of error, he claimed that the trial court erred in soliciting and relying upon the historical concerns of the cases involving the other children. Specifically, he's claiming the questions that the trial court asked the guardian ad litem were erroneous. In the trial court's findings, it made specific facts about the historical involvement. It found that mother had a significant history with Children's Services, and the parents had the children removed from their care, and they were given an opportunity to work the case plan, but failed to work the case plan. Those statements and those findings by the trial court is all based on evidence that is already contained in the record. The adjudication entry, which was agreed to by mother and father, very clearly said that the other children were placed in relative care due to, and I quote, mother's ongoing drug use, mental health concerns, and inability to meet the basic needs of her children. Additionally, the entry also said that the parents had significant children's services history.
So it sounds as if your opposing counsel is saying, okay, that's what the entry says, but the record's not before this court, there are no exhibits, there are no transcripts. How do you respond to that?
There were 3 exhibits that showed that the other children were placed in the legal custody of relatives. Additionally, I believe mother's own testimony supported the record in this case. When I am talking about the adjudication entry, it is the one in this case. But mother's own testimony supported all that other evidence in that she testified that she had her children taken away from her because of her cocaine use. Additionally, she testified that she moved to Lorain County when DB was born in order to avoid children's services involvement. So I believe that mother's testimony corroborated that. Additionally, the guardian ad litem did testify about her involvement in the past, and she does have the ability to testify about that, and it would not be hearsay for her because she was personally involved in those cases. She was the guardian ad litem for about 1.5 years for the older 2 siblings, and then she was the guardian ad litem again for the 3rd sibling, KB. Therefore, the testimony she offered was based upon her own personal knowledge. Additionally, then, as to father's 3rd assignment of error, where he claims that he received ineffective assistance of counsel when the counsel failed to object to the hearsay statements of the drug screens and what the father's physician had said about father, father cannot prove that his counsel was legally deficient. For an ineffective assistant of counsel claim, there are 2 prongs that must be proven. The first is that trial court counsel was deficient. In this case, the counsel was not deficient. This court has held that failing to object to hearsay alone is not sufficient to sustain an ineffective assistance of counsel claim. Additionally, the testimony about the drug screens could have been a trial strategy or trial tactic of father's counsel. Based on father's testimony and then the cross-examination of father's counsel, it appeared that father's theory of the case and the theory of the positive drug screens was that Children's Services was putting cocaine in his drug screens. Father's court counsel went with this theory, especially when he was cross-examining. So I believe that deference needs to be given to the trial court strategy. Additionally, father's claim that firing trial court counsel demonstrated ineffective counsel, I think, also fails. The trial court noted, for the record, the observations that the trial court saw father's counsel do throughout the case, such as writing notes to father, going to father to ask questions about the questioning of his witnesses. Furthermore, the record is very clear that father's counsel was cross-examining witnesses and was actively participating. Therefore, trial court counsel was not deficient. Additionally, father cannot demonstrate prejudice with respect to these hearsay statements. As to the drug screen results, there was one line in the entry that says that parents have continued to test positive for drugs. That testimony, that evidence is found in father's own testimony, and it is also found in the first extension entry.
And you have reached the end of your time.
Okay, thank you, Your Honors.
Thank you for your presentation. Counsel, you have 5 minutes remaining for rebuttal.
Thank you, Your Honor. I wanted to respond to the issue of standing. The case cited by my opposing counsel was not a 9th District case. When you're looking at an analysis of when somebody has standing, I believe I would contend that the primary issue is whether this person's rights were impacted by errors made. So if father is allowed to challenge errors made when a court does not grant legal custody to a non-parent, there doesn't seem to be any reason why father would not also be allowed to challenge errors made with regard to another parent. This court has stated that when errors made with regard to a non-parent impact the parental rights of the parent, that there is standing. So my contention would be that really the question of whether the errors were made with regard to a parent or a non-parent is irrelevant. That father's parental rights were impacted by the court's finding that mother, errors with regard to mother. The second issue I wanted to address was the matter of whether the agency did what they needed under the law in considering Linda Brooks as a potential caregiver. The agency argued that Linda Brooks delayed in getting her fingerprints. She refused to come up to Lorain County to visit with the child. The testimony at the PC hearing actually showed that the agency gave Linda Brooks a deadline of until October 5th to get fingerprinting. She got her fingerprints on October 7th. However, the agency canceled the home study that was supposed to happen on October 9th because of this 2-day delay. In the context of the fact that Linda Brooks was originally contacted in late September, this was not an undue delay. The second aspect of the visitation issue is the agency required Linda Brooks to provide 4 days' notice for her to come up and visit the child. On at least one occasion, Linda Brooks testified that she stated that she was able to come up and visit the child. However, the agency would not allow the visit because, as Linda Brooks testified, the agency said it was not far enough advance notice. So there were roadblocks set up by the agency as far as deadlines that were not really set for any reason, and they were quite arbitrary.
Can I ask you a question? I see we're talking about dates in October. She was originally scheduled to do the fingerprinting on October 5th and didn't go until the 7th.
The agency gave a deadline of October 5th.
And she didn't go until the 7th.
She got the fingerprints on the 7th.
And how far into the case were we at that point? Because the trial was set for October 16th and 19th, so it was just less than 2 weeks away that the trial was scheduled to go forward.
Right, and I'll concede that Linda Brooks was not even discussed as a possible placement. She wasn't brought forward by the parents until very late in the process.
And also there's the issue of the strained relationship between her and her sister and the prior CPO. And
there had been a CPO. It had been expired by the time of the hearing. So, unless there are other questions.
So by a number of years it had expired.
Yes.
Thank you.
Thank you
both
very
for
much.
your presentations. The court will take the matter under advisement. We will issue a written opinion, send it to both sides, and do check the Supreme Court website in the interim. We are adjourned until